If you receive a statutory demand, the strategy to deal with it depends on which category you fall in. Either you can pay, you can't pay, or you won't pay. I'll start with the easiest. If you can pay, you should pay, and that will resolve it. If you can't pay, I think you need to get some specialist legal advice at this point because the timeframes move very quickly. Once you receive a statutory demand, you have 15 working days to pay. If you don't pay, the creditor is entitled to then file a liquidation application at the High Court. Another time frame is if you dispute it, you have 10 working days to do that, and you need to do that formally at the High Court. So if you can't pay, you might want to look at either negotiating settlement, coming to some arrangement with the creditor that is going to work in with your cash flow and their expectations. If that's not possible, you need to move very quickly to then look at other options like liquidation or restructuring. Now, if you won't pay, it's usually because you have a dispute of some form. So, in the construction industry, it's very common for statutory demands to be issued, but the debtor has issues with the workmanship or the quality of what's been done. And so, or maybe there's been an overclaim. And so there is a dispute there. Now, in that case, you have 10 working days after service to file an application at the High Court to set aside the statutory demand. And if you don't, there is a statutory assumption that your company is insolvent and can be liquidated as a result. So no matter what strategy we're talking about, there is a clear theme across them all. You need to be proactive in dealing with it. Doing nothing is the worst possible strategy that we see, and it's the most common strategy adopted by business owners. If you receive a statutory demand, book an initial consultation with expert lawyers. We offer this at our website at norlinglaw.co.nz.